Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. The court is open. Please be seated.
Thank you, Gio. Morning.
Morning.
Welcome to the Massachusetts Appeals Court. My name is Judge Desmond. To my right and your left is Judge Grant. To my left and your right is Judge Hodgins. Will be your panel for this one matter that's on today. We've read your materials. Familiar with the law, so I don't think you really need to go over too much of that. But of course, your 15 minutes is yours to do with it what you will. There's no rebuttal. And with that, we'll call our first case. It is 24P0486, Espinola v. Murphy and another. Mr. McCardle.
Thank you, Your Honors. Good morning, if it may please the Court.
Good morning.
Attorney Luke McCardle on behalf of the appellant, Eileen Murphy. As Your Honors can see in reading the fact section, it's quite a convoluted mortgage history regarding initial foreclosure that was deemed invalid, stemming back to a foreclosure in 2012. It took 4.5 years for it to go through the appellate process and to affirm the unlawfulness of the foreclosure. And once the appeals court affirmed the decision, the third-party purchaser at the sale then brought a separate superior court action against NationStar, who was the mortgagee who conducted the unlawful foreclosure. That ended up settling. I don't know what the settlement was between those two parties, but as part of the settlement, there was an agreement for judgment that was entered, which affirmatively voided the foreclosure deed, and revived and reinstated the mortgage, my client's mortgage, and that was January of 2017. In the midst, the history is important as far as the application of the law, because within that 2016 court case, all of the relative parties were involved. Service was provided, service was effectuated, so the last known place of residence was clear as of March and April of 2016, when the complaint and amendment.
Well, wasn't your client, Ms. Murphy's residence clear as of January 2017?
Ms. Murphy's residence?
Correct.
I didn't actually dive into this fact, which I was a mistake on my part, but she was actually served within that superior court action in her partial residence. So she lives down in Florida during the winter months with her children. It was not part of the record, but judicial.
I'm not talking about service in the superior court action. I'm talking about the bank giving her notice under paragraphs 15 and 22 of the mortgage.
Sure. It's
in the fall of 2016. Or
yeah, the end of 2016, correct. October 2016 is when they sent the notice out, the renewed notice of default, and they did send it to the mortgaged address where.
It was where she was living, right?
Which is her primary residence, correct.
Okay. Let me ask you this question. How long has she lived there?
She's lived there her whole life. Her parents built the property and gifted it to her.
Okay. And she refinanced it. She and Murphy refinanced it at one point?
During their marriage, they refinanced it, yes.
So Murphy left. When did he move out of that residence?
So the divorce decree was the end of 2008, so I would assume it was prior to that.
Sometime prior to 2008?
I'm just guessing, but yes, I would assume because of the facts of the divorce that's the case.
Okay. And what's the property look like? It's in Lowell, right?
It's in Lowell. It at one time was in good condition and a nice property, but because of the foreclosure in 2012, she didn't know what was going to happen, obviously, so she did not keep up with the property. It kind of fell into disrepair to some degree. That's why she doesn't stay in the winter. I don't think the heating systems work properly, so in the winter she goes and spends time with her children. She's a teacher, and I think at this point...
The question was, what does the property look like? Is it a single family? Is it a multifamily? Is it an apartment?
Sorry,
Is it a condo?
it's a single family residence. I apologize. I misinderstood the question.
Single family residence, a couple of bedrooms. How many bedrooms?
Say that again,
How
sorry.
many bedrooms?
How many bedrooms is it? I don't know off the top of my head. I don't want to guess. I would assume it's just a standard. My brother might know his client.
I have questions for him next.
Sure.
But how many, has she ever paid any mortgage payments?
Yeah, of course. She paid mortgage payments throughout from the time of the origination of the mortgage. They collectively paid the mortgage until the time of the divorce, when the divorce decree.
After that, after 2008, did she pay any mortgage payments?
No, because Paul was obligated pursuant to the divorce decree to pay the mortgage obligation until the children graduated from high school. And so when he changed the notice address.
When did the kids, show me, where in the record is that? Show me that.
The notice address being changed?
Yeah, show me that. Where in
It's,
the
you can look at the mortgage statement
I'm not
and,
interested in the mortgage statement. I want to know, where is it that he changed his mortgage address? That's what you just said, so I want to find the notice that he changed the address.
Well, I
Not
think-
a mortgage statement with a different address on it. I want the document.
that's all I have, Your Honor. All I have is.
That doesn't mean he changed his address. I don't
Right,
know how
but
they, I don't know how they ended up sending it there, but that's not a
But
change of
the
address.
facts were not disputed.
I'm asking you, you're citing in your papers that he changed the address, and I'm asking you to show me in the record where he did that.
It's in her affidavit.
I'm not interested in her affidavit. Show me in the record.
Those are the only records in the entire.
You can't show me in the record where he changed his address.
Because I don't represent Paul.
I know, but you
there's-
represent that
It's
he
impossible for me to understand that information.
You represent that he changed his address. That's your representation in your brief.
Based on an affidavit of my client and based on the clear evidence of the mortgage statements being changed, that if mortgage statements don't go to an address if the notice address isn't changed, all of the mortgage statements.
Is a mortgage address to which a mortgage bill is sent the same thing as a notice address?
Yeah, correct.
How do we know it's the same address? Can't somebody have an address to which their bills are sent, like someone's living in Florida for the winter, and they say, send me my mortgage in Florida for the winter, but the notice address for foreclosure could still be Lowell?
You can only have one notice address under paragraph 15.
Right.
So once you see that the mortgage statements are being sent to one address, that is the only notice address.
Where does it say that the mortgage address, this address on the mortgage statement is the notice address?
It's implied as part. It's implied as part of the contract. Once you change the notice address, that's where all of the documentation regarding the mortgage is sent to the notice address.
So if somebody says, for the winter, send my mortgage statements to Florida, then
They would have to change it back if they wanted to change it. They would continue to go to Florida forever until the notice address was changed. That's my understanding about paragraph 15 has always worked with mortgage companies. Once you provide a notice address, if you change it, it stays that until you change it again. And
Where would
that
you change it at?
you'd have to give direct notice.
So how come you don't have that?
How come I don't have that direct notice?
You seem to be relying on that.
Because it was effectuated 15 years ago at some point. I don't
hear Mr. Murphy saying I changed the notice address.
Mr. Murphy's not part of this proceeding.
I understand. Ironically.
Sure. I don't have a great answer for you, obviously, on this subject, because it's evidence that I don't have. Nation Star wasn't a party to this case. We did RFIs and requested all of the information
so
from them.
speaking of Nation Star not being a party to this case, why doesn't your client just have a cause of action in probate court against her ex-husband or against Nation Star and let Mr. Espinola have the house he bought as a good faith arm's-length purchaser?
Well, there's no good faith arm's length purchaser at a foreclosure sale. But you're asking, like, she's defending herself in an eviction proceeding. This is part of it, as the law has become part of the law, whether it's a third party pursuant to Pinti Bevilacqua, they still have to prove superior title that the foreclosure was done lawfully. The only person that can be brought against when you're about to lose your home and then you're being evicted is against the party that's bringing that case against you. So I'm a little confused by, could my client affirmatively taken this in another direction? Sure, but she's here and she has to defend herself in this matter because that's the matter presented to her. The foreclosure was conducted basically without her knowledge, without notice of the default, without notice of, I think just diving into it, since I'm losing a bit of time, whether it was the notice address or the last and usual, Paul wasn't provided
How do we know Paul wasn't provided? Is there an affidavit from Paul on the record?
We have the record of the default notices. It was absolutely not sent to his address, the notice address, or his last and known. It can't be, I think it can't be disputed. We have the record notice of defaults that were provided as RFIs from NationStar. Those were the only default notices provided, the ones that were sent to the property address, care of our offices.
So she never paid any mortgage because she was under the belief that Mr. Murphy was paying the mortgage. And by the way, was it an acrimonious divorce?
Was it a
acrimonious? Was it?
I mean, it seemed like it got relatively contentious. There was a bunch of contempt, back and forth orders regarding the non-payment when she found out about this, because part of the divorce decree was he was supposed to deed her the property. He never did it, and then she was supposed to refinance and pay off this mortgage and get into her own payment plan within the 2-year period prior to their kids going to college or whatnot. There was some period of time where he was supposed to continue to pay. When she goes to refinance, she has default on her record. I believe that's when she first found out about the default status, because she wasn't receiving direct notice, and that's when she retained our offices. For months we tried to even talk to NationStar. They wouldn't speak to Miss Murphy or my office because they said she wasn't an obligor on the note, so she didn't have authority to deal with loss mitigation or otherwise deal with the mortgage obligation, even though she's a borrower.
When she got that communication, what did she do? When she said, I can't even communicate with them because I'm on the note, did she have some conversation with Mr. Murphy about how to resolve that?
Yes, because it was during the contentious divorce period and they were going back and forth, it took my office a lengthy time to even get authorization from Paul for us to be able to even talk to NationStar to try to deal with it. And by that time, they had already pushed to foreclose, and that was the first foreclosure back in 2012, and that's why we had to unwind that one. Sure. And I think the bigger issue is that she was more than willing to sell the property and pay off this loan in full. She preferred not to. She wanted to refinance it, but the default status got in the way of her refinancing abilities because of, obviously, the credit situation. If you have any default on your record regarding a mortgage, they won't allow you to refinance within a certain period of time.
Let me ask you this question. What did I think it's Mr. Espinola, did he do anything wrong? Or
Absolutely not.
Or does he have completely clean
He's a third party. He's an innocent third party, 100%.
Bona fide purchaser, right?
He's not a bona fide purchaser. It's not the law, no.
But clean title. He got a title examiner. There was an affidavit that was attached to it. What would have led him to believe that there was some infirmity? Sure,
there was actually correspondence during the title examination that he suggested to the title attorneys at Harmon Law or the foreclosing attorneys that they thought that it might be a defective foreclosure. There's actually correspondence that I cite within my brief that goes to Harmon Law, and Harmon Law has to try to substantiate the validity of the foreclosure. There's exhibits within my submission regarding it already being an issue and the title might be a problem.
That was from the first round?
No, this is the second round. And
is that because of the words CO Law Offices of Michael M. McArdle included on the address?
I think that was part of it. They were saying that they thought that it wasn't effective notice as well.
What's your best case that says that having extra language like that in the address?
I honestly don't have a best case for that. I haven't seen one, to be honest with you. We did look to see if that was something that had been decided at the higher court level regarding notice to the attorneys. I presume it wouldn't be a huge issue, other than the fact that this care of was sent to a law office that address that didn't exist, and the nation.
But it had your client's name on it at that address.
It certainly did. It had my client's name on it at that address. They were also all unclaimed and returned to sender, so they had noticed that they weren't received, notwithstanding, I know notice is assumed on mailing, but the fact is that actual notice wasn't received because they were returned to sender, and the documentation shows that within the exhibits. I think the other aspect of the case is regarding what do you do when you have an unlawful foreclosure that takes 4 years to unwind, and the bank says, oh, we get a do-over. We're just going to add in all of the taxes and insurance and late fees and interest onto this loan and just saddle it onto the top of the loan and say, now you owe $100,000 to reinstate instead of $5,000 to reinstate at the time of the foreclosure. You do an unlawful foreclosure. 4 years, and you say, oh, oops, redo. We're just going to add in all of these expenses on top of your loan and then demand payment as soon as we unwind the foreclosure. How is that fair?
Where does it say that the notice that was sent to your client at 44 Eastview Street was returned to sender? Because I see at page 372, it says first-class mail, 10/19/2016, Waltz event mailed. I don't know what Waltz event means, but it says it was...
Well, first-class mail, you don't have any idea because they don't have a record of it received, but the ones that are certified, that are above that, they show that they were all unclaimed. So
well, does paragraph 15 require more than one manner of service?
Paragraph 15, as it relates to applicable law, requires, I think it's either or. It's either or.
Right, so why isn't this first-class mail sent to this address valid service under paragraph 15?
It might, there's an argument there. There's an argument there, but there's two borrowers.
I understand there's two borrowers. Mr. Murphy's not complaining, right?
He's not here complaining.
I get it.
What do we...
Exactly. Well, this is the place for him to be doing it.
Sure, but he is the obligor on the note, so I understand that. There's a little bit of a gray area there, but it was also not sent to her known attorneys of record.
What do we do with notice to any one borrower shall constitute notice to all borrowers unless applicable law expressly requires otherwise? Do you have a case that says that notice to her?
I think the Benson case is the one case that I cited regarding the application of paragraph 15 and 35A and the manner in which the notice needs to be sent. Otherwise, I agree. There's some arguments that there's gray area because there's not really any sound decisions at the higher court levels regarding some of these issues, especially regarding the accounting issue is a huge one for me, which I think we can infer from the fact that paragraph 22 says shall inform the borrower, which is defined as both borrowers, notice needs to be sent to both borrowers under paragraph 22, and it says you need to provide them notice of the default, the amount to cure the default. If they send an erroneous amount to cure, how is that strictly compliant?
What do we do with, in paragraph 15, the notice address shall be the property address unless borrower has designated a substitute notice address by notice to lender? You want us to infer from that 2011 mortgage statement sent to Derry, New Hampshire, that as of 2016, the notice address was Derry, New Hampshire?
Well, that combined with the affidavit from Ms. Murphy that said no statements or anything was ever sent to her property address. She had no idea what was going on because none of the correspondence from the mortgage, and you can see from the correspondence with Nation Star that they didn't deal with.
She says things like, I never received this default notice, but my attorney provided me with a copy years later, and I had no notice of the foreclosure or that Nation Star was again seeking to foreclosure until in or around the time of the auction. She's very vague about when she received notice of things. Can't we infer from that the first-class mail notice was actually valid?
I would say no, but
why do you say no to that?
To be able to infer that the first-class mail notice was valid?
Yeah. Why do you say no to that? I mean, they sent it to her address. Why would you say that that's not valid?
I would say it's not valid because that was not the notice address under the mortgage.
I mean, it seems that they were trying to send it, having gone through it the first time wrongfully, incorrectly, that they were trying to send it to every place they could think of to make sure that they got the notice correct.
I think it was the opposite because they were just involved in a Superior Court case where they had notice of of Paul's addresses and Eileen's Florida address, my office address, and they didn't send it to not one of those 4 addresses.
I thought they sent it to the property address.
They sent it to the property address.
And
That were sent, care of my office to the property address, correct. But they were also just on notice in the Superior Court action that she resided during the winter in Florida.
Does paragraph 15 say unless the mortgagor has notice from a Superior Court action about a different address?
No, but that's applicable to 35A because that's actual notice of your residence and your last unusual.
You know, I'm still hung up on what you said about it being returned to sender, because that actually, you'd agree, that's actually not in the record, right?
That it was returned to sender?
Returned to sender.
Correct.
Okay. So the best you have is that the notice was sent to that address, just had additional names on the address, right? Your father's name, right?
Correct.
Okay. And it was unclaimed.
Right.
So that could be the person at the residence sees it in the mailbox, I'm not touching that, and just leaves it unclaimed, right?
Potentially they can do that if they knock on the door and try to serve it or get the green card receipt.
So that's a possibility that it's just like willful blindness. Well, I'm not gonna.
Certainly. The facts do show that she wasn't actually at the property during this time period over the winter. So I would argue actual notice absolutely didn't happen. Did they pass muster as far as legal notice to the property? If that's declared the notice address, and to some degree, did they pass muster on that? Maybe. Would it be a fact that should be disputed and gone to trial on? I think probably. Because we probably needed more evidence and testimony regarding some of the gray areas that you guys have brought up that I don't have all the answers on. And the judge determined at the lower court level that there was no material dispute regarding the facts that I outlined in the summary judgment motion that were supported by enough evidence in his eyes that there was no dispute as to those material facts. So then he was just saying, but the application of the law is what his decision was based on, and that's what I'm asking you guys to base your decision on, the application of the law to the facts that he determined were not in dispute.
I think we get it.
Thank you, Your Honor.
Thank you. Attorney Eaton.
Morning, Honors. Representing Gene Espinola, the appellee in this matter.
Was notice changed by Mr. Murphy?
I don't know. But it was, as far as I can tell from the record, it was not changed for the appellant. It has always been the property address from all of the evidence presented. That has always been her mailing address, as appears from the record for Nation Star.
At the Lowell property?
At the Lowell property. And as we've discussed, the mailing was made to the property. Evidence of the mailing is there, although unclaimed, and rightfully noted that the regular mail was not apparently returned. So that mailing in and of itself is compliance with paragraph 15. Notice to one is notice to both, so that issue seems to be resolved because of the proper mailing to the property address to the appellant.
What about the foreclosure sale, or what, if anything, would have put Mr. Espinola on notice that there was some infirmity with the title of the property?
Well, I suppose it would have been some sort of declaration or producing of all the relevant documents we have in this particular case prior to the foreclosure sale to put him on notice that there might be an issue. But those at a foreclosure sale, the purchaser technically is a bona fide purchaser under 35B and C, not having any notice of any infirmities. And he goes there with the assumption that the foreclosing mortgagee has complied with all the requirements. There is some investigation done after the foreclosure sale and prior to accepting the documents for recording, but that entails generally reviewing the notice to make sure it was sent to the proper address and complied with Chapter 20, Paragraph 22, which the notice does, and all other items in connection with the foreclosure were properly done under Chapter 244, Section 14. For proper foreclosure, that would be the extent of a bona fide purchaser's purchasing at foreclosure sale.
Was Nation Star aware of the property that Mr. Murphy was in New Hampshire?
I do not know. I assume they were because some notices were sent to Mr. Murphy in New
You
Hampshire.
say notices, do you mean notices or do you mean the mortgage statements?
Notices of the foreclosure sale itself in connection with 244, Section 14 were sent to a lot of people, including New Hampshire. But again, compliance with the mortgage terms as required is sending notice to the one or two mortgagors at the property address with a proper paragraph 22 notice, and that was done by Nation Star in compliance with those mortgage terms.
What's the status of the property today?
Probably not livable, Your Honor. As far as I know from my client,
So nobody's in it?
no one's in there. It's empty. Has been for quite a while. Might not be his best investment.
In the course of discovery, if Nationwide, not Nation Star, had been asked for the entire loan file, would a notice of a change of address be included in that package that would be sent to the other party?
I'm going to assume if there was a change of address, it would be included in the file, or at least evidence of that could be provided in a properly made discovery request.
But you've never seen it?
I have not seen it, no.
What else would you like to tell us?
Excuse me, Your Honor?
What else would you like to tell us, if anything?
Only that my brother brought up an unfairness argument, and I don't see that in that the appellant has been on notice since 2008 that she was going to be responsible for the mortgage payments after 2010, according to the divorce decree, and she made no payments or has made no payments ever after that date on the mortgage, nor has she sought to. There's no evidence of refinance, no evidence of selling the property, no evidence of putting title in her name through appropriate procedures in the divorce situation. So the unfairness argument seems to weigh in my client's favor as opposed to the appellant.
Sorry, I can't hear you.
The unfairness argument seems to weigh in my client's favor, not the appellant's favor.
Just out of curiosity, what was the use and occupancy payment?
It's $1,000 a month per the appeals court judge's order. No, I have nothing further, Your Honor.
Matter stands
Thank you.
submitted. Thank you both. That concludes our business and our session for the day. Court's in recess.